What's up, big sex?
He's my fence line. What are you doing? Oh, I'm ready. Getting those guys on board.
I love it, man. Smile.
Really want to be
Not fresh. It's you.
They all gets out.
It's probably a good thing.
So it's. We look bad. It look bad. Got to see how.
Break the day.
I always told you.
Hey, John, how are you, sir?
It burns. It burns every year. It's best grass country. 20,000 of that on the west side of that thing used to be my wife's family. They took it from condemnation. It's best grassland. But it does. It burns every summer. So we like that. Like that. Guess I'm gonna have to do it. Really pristine, because we don't have a farm.
We got the choice.
Yeah.
Country. I don't know where Mark is. Anybody heard from Mark?
He'll be about 30 minutes late.
30 minutes.
Okay, we'll call the meeting to order, emergency meeting of the Wildlife Commission. We'll have a call to order. Roll call, please.
Commissioner Chapman? Commissioner Dill? Commissioner Dunn?
Here?
Commissioner Mabry will be here shortly. Commissioner Zelfs?
Here.
Commissioner Baruch is absent. Commissioner Kane?
Morning.
Commissioner Holter?
Here. All right, we now have an introduction of guests.
Sarah Lacey with media. Representative Timmons.
My committee.
Oh, wonderful, thank you.
Glad to be here.
Thank you.
Thomas Markham, representing Cody Shepherd. Dakota Wapakichi with KOCO 5.
Thank you. Okay, at this time, we need to vote to enter into executive session to discuss pending litigation that could immediate financial loss in Oklahoma Department of Wildlife Conservation.
Order, please. New representative. Just wanted to know, I know that we had a stance by State Department of Ed person that said, superintendent of schools said that the legislative members could not come back into executive session. And I think there was some litigation about that. And I'm not, but are you all taking the same position that as a state rep, I was on the committee, the wildlife committee, that I'm not to be in executive session?
Not to dodge your questions, but I'm going to object to the executive session here today. If I may, Mr. Chairman.
Yes.
I don't want to interrupt you, ma'am. Is
No
that?
problem. So basically you're saying wait till we figure out if we're going to have one?
Yes, ma'am.
Thank you, appreciate that.
May I, Mr. Chairman?
Yes.
As I understand the executive session statute, which is 25 Oklahoma Statute Section 307, B4, in order for this body to enter into executive session, we must first do so on the advice of counsel, and it must be for the purpose of engaging in confidential communications with our counsel. I have grave concerns about whether or not we have counsel, and with the chairman's permission, I would like to ask some questions of the representative of the Attorney General's office.
Yes, proceed.
Somebody from the Attorney General's office that can answer a few questions.
Commissioner Kane.
Nikki Batt, for the record. Ms. Batt, are you, what is your role with the Attorney General's office?
I am the chief of the legal counsel division that provides representation to the various state agencies. I do so in my capacity under the Attorney General, who is tasked with advising state agencies that might have an statutory exception.
What is your title?
Chief of legal counsel.
In that capacity, have you represented the Oklahoma Department of Wildlife Conservation? And have you provided it legal counsel? Who are you here on behalf of today?
Wildlife.
Who sent you here today?
I'm here in my capacity as an employee of the Attorney General's office. Here in my capacity as counsel for the Department of Wildlife.
The event of litigation between the Department of Wildlife Conservation and the Attorney General's office, who would you represent?
There would be a screening memo put in place, and I would represent the Department of Wildlife.
You would continue to represent the Department of Wildlife Conservation against your boss.
There would be a screening memo in place, and depending on the circumstances, that would determine what my role would be.
Are you familiar with a letter that came from the Attorney General dated November 13th, 2025?
I've seen this. So, Mr. Chairman, are we going to take a vote on the motion? I mean, at this point, I'm not involved in the discussion. I'm happy to have any conversations you'd like to have, but there is a motion, and I think that you should move toward the motion. If there are any concerns, we can have that separately.
Well, I disagree, ma'am. In order to enter into executive session, we must determine whether or not we have counsel. You're here representing that you are our counsel, and I think I have a right to determine whether or not you have a conflict of interest.
I told you that I represent the department. I have always represented the department. Most of you know me, and I've stated that in the event that litigation does come about, there would be a conflict, or there would be a screening in place, and I would not be in any way involved in any litigation.
Okay. Are you aware that our director is absent today?
I am.
Where is he today?
Is at a beginning of a lawsuit in the Janus case, also defended by the Attorney General's office.
And are you aware that the letter dated November 13th, 2025 from the Attorney General demands a response by 5 p.m. today?
I've seen that.
And were you aware that the director was absent today?
I stated that I'm aware that he is in trial.
Were you a part of the letter dated November 13th, 2025? You're not involved in that?
I was not.
Did you advise the Attorney General that the director was unavailable?
I was not aware of the letter.
Has the letter been provided to the media?
Not aware of that. I don't know.
Cameras in the background make you aware of that?
Well, I certainly saw the car when I got here.
Are you aware of a statement in that letter in which the Attorney General threatens litigation against this department?
I saw the letter.
Have you advised us on the matters involved in that letter in the past?
In August of 2024. I had not advised since that time.
Do you agree with the Attorney General's analysis in this letter?
I think that they're largely I do, depending on the circumstances of what it is that we're talking about here today, which I have to admit I'm not aware.
Ma'am, have you sent any emails to members of this commission concerning the Strobel case?
I don't recall.
If there was a letter, or if there was an email from you stating that the Strobel case was on point, would that be correct?
I would need to see the email in context.
If I were able to produce that email right now, would you be able to take a look at it?
Happy to.
Give me a second. I got a pile of papers here.
We're in, I'm not sure. No?
Is your email, ma'am?
of this email. The context is important, but I did send an email in what appears to be July of 2024 that says that there is a case that is pending and that will need to continue to monitor.
Okay, and would you
That
read the
was-
full highlighted portion of your email for the commission?
I didn't hear you.
Would you read the full highlighted portion of the email for the commission?
Yes. We are waiting on a decision, but we will continue to monitor. That is part of the analysis.
No,
that
that's
was
not what it
taken.
says, ma'am. Would you read it, please?
I am not being deposed here, okay? I am here for advice of counsel to the department.
I'm of the
And I
opinion that
told
you have a
that
fatal conflict of interest.
This is
in it.
advice I gave in July of 2024.
If you're not going to read it, ma'am, let me read it. You bring it back to me, please, or I'll get it. Commissioners, in the email that Ms. Batt just said that she wrote, he said, while I continue to review case law, I'm aware of a case on point that is currently before the Oklahoma Supreme Court, in parentheses, Strobel versus Oklahoma Tax Commission. This case was argued in January of 2024. We're still waiting on a decision from the court, so we continue to monitor. Agree that that's what you stated, ma'am?
That is what I stated, sir, and I will tell the commission that that is but one case that would be something that we would want to review and to consider.
So would you agree with me that you've given conflicting advice to this commission,
I would not agree with that.
despite that email?
That is but one case that would be important to know.
You've also stated that you may not fully agree with the Attorney General's analysis.
That's not what I meant is I am not aware of the circumstances that have brought us to the point where we are today in the change in policy.
Challenge the record on that. Have there been any other occasions where your office has provided statements to the press that conflicted with your advice?
I'm not going to answer that question because of pending litigation.
Fair enough. You believe that that this commission is entitled to legal counsel in responding to the type of query that we received from the Attorney General?
That every state agency is entitled to representation.
Are we to believe that you could provide effective response to that letter when you work for the Attorney General?
I have an ethical obligation. That ethical obligation is to this commission and to this department, and I will do that in the event that there is litigation. I've stated now 3 times there would be a screening memo in place, and I would not be involved in any way in the litigation.
Speaking of ethical obligations, do you have an obligation to provide us with confidential communications?
But depending on the circumstances.
Do you believe that producing letters to the press is consistent with that ethical obligation?
As your counsel, not produce anything to the press.
Is the Attorney General our counsel?
Yes, he has different considerations that he has in mind, but certainly yes.
Thank you, Ms. Batt. I appreciate the tough position that you're in, but it is my opinion, members of the commission, that the Attorney General's office has a clear conflict of interest in this matter and cannot serve as our attorney. As a result of that, we have no counsel here to advise us to enter into executive session, and no counsel with whom we can communicate with confidentially in executive session. So I have the opinion that we cannot move into executive session today.
Mr. Chairman,
Yes.
I'm going to take the opposite opinion. I think Ms. Batt has clearly demonstrated, she says she has no conflict of interest. She is our legal counsel. I'll make a motion to go into executive session.
Mr. Chairman, I would second that motion under the auspice that I would like to hear from Ms. Batt on what she has to say and advise in this matter, and would like to defer my opining on Commissioner Kane's opinion until I have more information.
Further communications, Commissioners, privy to further communication from Ms. Batt last night, saying that the agenda that is before us is legally insufficient. So I again think that that is unwise.
Commissioner Kane, thank you for that additional information. Could you share more? Is it appropriate to share more on that?
Ms. Batt? I'm going to have to dig for it.
Mr. Chairman, I have some concerns that we're going to reveal confidential communications from our attorney to us here in open session. Again, I would re-urge that we take a vote and go into executive session. We'll be able to discuss candidly with our attorney whatever issue she has and make a decision what we ought to do then. But I think the public forum to get her to reveal confidential information given to one of the members of this commission would not be appropriate.
Well, the advice in question was given to the assistant director last night. I'm not sure if I can pull that up, but I'm certain that Ms. Batt advised the commission that there was the agenda before us is legally insufficient. I'm not going to hide the ball. My position here, gentlemen, is that we need legal counsel, and we don't have it. And if the Attorney General wants an answer to his questions, and I believe there are good answers, but if he wants those answers, we have to have an attorney help us do that. The deadlines that the Attorney General made up out of whole cloth were not designed to give us time to respond effectively. They were given when we had no meeting scheduled. They're given when we clearly do not have legal counsel. If he wants an answer to those, I'm happy to give it, and I think we should give it. But we need to hire an attorney to advise us.
Well, Mr. Chairman,
Yes.
there again, I'm not sure legally our role to hire outside counsel when we have counsel. We've been advised by the chief legal officer of the state of Oklahoma to do certain things, and I think we ought to have a fair and frank discussion in executive session about that. I don't know that we legally can go forward and hire counsel. We have counsel, I understand, and I appreciate Mr. Kane's opinion that there's a conflict here, but I'm struggling to see it, and it's probably because I don't have enough information. But I think we ought to have executive session and figure out what we need to do.
If I might, Mr. Chairman, Nikki, is there any, do you know of any information based on our agenda, the timing of the agenda and the called meeting that calls into question the legality of this meeting and our ability to go into executive session?
I have that information. I'm sorry to interrupt, Ms. Batt. What I have is a transcription of a voicemail sent to Director Free last night. Wade, it's Nikki. I was just on the Commission's website and see that the agenda posted for tomorrow is still not updated to include the appropriate statutory provision, so someone needs to get that taken care of. Otherwise, the Commission won't be able to go into executive session. Ms. Batt's communication last night.
Do you still stand behind that based on how the meeting was posted?
I haven't seen whether or not that agenda item was up. I'm not trying to avoid your question. I just, sitting here, don't happen to know. If it has 307B4 on the agenda that you have available to you, then that opinion would be no longer.
Commissioners, we can't get straight advice out of the Attorney General's office. I don't know how any of us can expect to move forward without effective legal counsel. It puts us all in jeopardy.
Nikki, you need to see what it says.
Yes, sir. It does appear, actually, I'm looking down at this. I will say that the agenda was not sent to me for approval, and so I would have caught that earlier had somebody sent it to me. but that did not happen. And it does not have B4, which is a requirement to enter into executive session.
Based on that information, I remove my second.
I'll withdraw my motion.
Commissioners, I don't think we can take any action here today. It's clear. But I think we need to move towards hiring our own legal counsel. I would like to suggest to staff that they run that to ground so that we're in a position to vote on hiring legal counsel at our next meeting.
Okay, this has been a good discussion, and at this point, we do not have a motion to go into executive session. What I would like to say is, we still have lingering concerns about the threats and personal liability that have been made toward the OWD staff, particularly our game wardens, knowing that we cannot take any action in this meeting. I would just like to express my opinion, my personal opinion, this is not the commission's, as Commissioner of District 7, our wardens should avoid making arrests or confiscating property from tribal members until we have been able to secure outside counsel to advise us on these matters. I'm not suggesting that tickets should not be issued for violations. They should. I'm suggesting that arrest and property confiscation should be avoided until we have received further legal counsel.
I appreciate that sentiment. Our game wardens are our first concern here. And I think it makes a lot of sense to ensure that people are being held responsible for violating the law, but there's no reason to escalate a conflict. So I think that's good advice, and I share it.
And for the protection of all our constituency, which includes tribal members. As Thanksgiving's coming up next week, my wife is a member of the Cherokee Nation, and my kids, my grandkids, my brother-in-law, they're members of the Choctaw Nation. I love them dearly, and I want them protected as well as I want our game wardens protected. And as this plays out in the press, is not productive. Myself, and I believe every member of this commission, works up here non-paid to support the wildlife department and do what's right for our state and our tribal partners. We love our tribal partners. We're not posting rhetoric out in the press. We want the rule of law followed. I'm not an attorney, but I will follow the rule of law wherever it leads. And for us to be threatened and this to be played out in the press is something that I wasn't raised that way, and I don't believe in it. I believe in the rule of law, and I will follow it, and I will protect my family, and I want to protect our game wardens.
Well stated.
We have 350 employees at this commission that have, many of them have dedicated 10, 20, 30, 40 years of their life to make this place a better place to hunt and fish. We have to abide by our bagging limits. We have to abide by the hunting seasons. These are all things biologists have designed for the purpose of making hunting and fishing better for the citizens of this state. And we have to be able to enforce those rules if we want to continue to have this type of state that people are coming to hunt and our citizens have a great place. We want this resolved, and I think the people of the state want this resolved.
And without politics.
Without politics.
Politics really don't play a part. And I would just like to say on behalf of myself, and I really appreciate my fellow Commissioner Kane, the position that he's in, and I hope you understand the position that this commission's in. But Ms. Batt, I'm also sorry that you were put in this position by someone within your office, and that we had to ask the questions that we asked today. And we do appreciate your past and current efforts to give us advice. So thank you.
I do want to make a comment. I've served almost 16 years on this commission, and I can't remember a time that I was in the minority about anything. But as a lawyer, I think we ought to follow our lawyer's advice, which is the Attorney General's advice. And it's hard for me to go against that advice. I'd like this to be resolved in court. I've read the Strobel opinion. I don't think it applies to us in this situation, but the court's going to have to decide that. But I think that we're making a big mistake when we don't follow lawyer's advice, and he is our lawyer. And that's all I want to say for that.
We have any other comments? No other comments, meeting adjourned.
Thank you, Rick.
Yes.